Hello again, this is Ben Hitchcock Cross talking to you today. We're going to discuss Administrative Law Judge Stephanie Brown's attack on workers' right to organize. So we're going to have to unpack that a little bit, and to do that, we've got some background here on Stephanie Brown and who she is. Then we're going to get into the letter and her participation in all the MPS cases. We're going to talk about her um, let's say, attempts to separate Dr. Keither from Dr. Garcia Hoven and Dr. Ford. We're going to get into the letter that she wrote into that and our response, and sort of where that leaves us in terms of either the quality or the purpose behind all of this. So we're going to sort of focus here. I think we're going to have to break it up in a couple other videos about why exactly and how we can determine what this is, meaning why are the Department of Workforce Development employees coming together to try to keep workers from being able to combine their facts, combine their stories, listen to each other's stories, and develop, learn, and grow, and ultimately stop discrimination here, because we thought that that's what the mission of the workforce development people were, but we get the sense that that's not the case there. And even so, there's this concept here that there's all a bunch of liberals and that they should be Democrats and they should be working for workers, but as we're going to see here, that seems to be expressly not the case. So let's get into a little background here. Who is Stephanie Brown? Stephanie Brown has been an administrative law judge for a number of years. She has certainly she is deferred to. Investigators come and ask her questions. We've got emails on that. She responds, tells investigators what to do. Other people seek her counsel and advice. She's much like Alice DeLau in that sense. She had been an associate of Jeff Hines, I understand, for a number of years, and she left there and went directly to work for the state of Wisconsin. So those are her two employment experiences, is working for Jeff Hines and being an administrative law judge. She has certainly, put in, what I would say is she's the most experienced person of sort of this next guard, or someone, I wouldn't say even experienced, but on the forefront of the next generation who's below the people who are about to retire now. So, okay, now keep all that in mind. For some reason, all of my cases that are certified to hearing against NPS are being heard by Judge Brown. So we know that's no coincidence. We know that Heidi Marshall, who really holds no position in terms of, she's not supervisory to any administrative law judge, she's the one who's making the decisions in terms of who gets what cases. So we also find that there's sort of a consensus to determine who's getting mediations and so forth. But it doesn't seem like there's any official blind process there that you would find in normal courts that hand out cases on a round-robin basis or some other equal opportunity basis there. There's certainly, it's no accident that all of my Department of Corrections cases are with Alice DeLau. No coincidence. So, that can be helpful. It can be easier for her to have hear those cases, but at the same time, it can be prejudicial one way or the other. She's more likely to take facts from one case to put it to another. And I think besides everything else is why is the department making those kind of decisions about what ALJ, strategic decisions about what ALJs are taking what cases. You would hope that those decisions are being made on a much more like I said, blind basis. So that's expressly what's not happening here. Okay, so at some point it's clear that I'm representing both Garcia Hoven and Dr. Keither, because she's the ALJ on both of those. There is a lot of documentation here in which she is trying to expressly keep Dr. Keither out of Garcia-Hoven hearings, expressly keep Dr. Keither from learning about what's going on in that case and other things. Now, if Dr. Garcia-Hoven wants to share everything about his case, he can. If Dr. Keither wants to learn everything she can about a public case, she's perfectly able to do that. And so what's really suspicious here is these sort of rules that, or orders that ALJ Brown is making that are really focused just at keeping Dr. Keither and Dr. Garcia-Hoven apart, and for no other reason than that. No justification, no legal basis, nothing. Really. So there's those orders that she made saying that Dr. Keither can't go to her deposition, that, you know, she tried to hide it and say that nobody but myself and Dr. Garcia-Hoven could go to Dr. Garcia-Hoven's depositions. Well, it turned out that that really meant Dr. Keither, which because it was obvious, and when she got called out on it, she admitted it. So that is part of the problem. So when faced with all this, it's fair to say that Dr. Keither asked Judge Brown to recuse herself. She refused to do that. In her refusal, I think it's pretty clear that she failed to grasp really the basis of why Dr. Keither was asking her to remove herself from Dr. Keither's case. And besides, again, this trend of actively trying to keep Dr. Keither and Dr. Garcia-Hoven apart, there is the general sense that Dr. Keither and Dr. Hoven are being prejudiced by Judge Brown, meaning that their cases are being harmed merely because they're connected with one another. So that is really the big overall concern here. Today we're going to focus just on one part, this letter that Judge Brown wrote in July. Now, setting up that, we need to be clear that this letter comes out at the end of July, and in July, about July 15th, Dr. Keither, Dr. Garcia-Hoven were supposed to have a hearing in front of Judge Brown. Judge Brown canceled that hearing. She canceled it directly after Dr. Keither and other members of the public said that they were going to attend this hearing. So the whole point of canceling the hearing, and we can get into the paperwork of all that because believe me, we've got it, was to keep Dr. Keither out of Dr. Garcia-Hoven's hearing. Okay, now we maintain that this is a public hearing, that we have every right to the video. We have every right to have anybody who wants to show up can show up. It's a court proceeding. My goodness, what do they have to hide? Well, ALJ Brown, Alice DeLau, and let's say her name is Seltzer, Maria Seltzer. She is the head of the ALJs there. She all said that they can cancel they can keep people out of pre-hearings because pre-hearings are not hearings. Because if you don't, their reasoning is as follows: if you don't show up to a pre-hearing, they can't cancel your case. Well, so that's just false. So that, you know, really is a problem. When we brought that issue to the secretary of the department, it's fair to say that we were retaliated against by those people who we were complaining against. We're going to get into that, I'm sure. Man, is it hard to focus on just this one issue. So the point is that leading up to this, some 2 weeks before ALJ Brown writes this letter, she canceled a hearing like not even business hours before the hearing was supposed to happen, and she did that in the face of complaints by Dr. Keither to her supervisor and her supervisor's supervisor about Stephanie Brown keeping her out of, and other members of the public out of a hearing. So that's, you know, that's and to be clear, it's like this. It's like you go to court, there's a scheduled matter, you're there appearing in the peanut gallery, as they say in the gallery, and you are show up and the judge closes it and you say, what's the reason? And she says, because I said so. That was sort of the level that we were at. And then when we go and say, hey, you know, department, I don't know what's going on, but you can't just, there's no rule here that says you can do this. You're just making things up, and because I said so is not a valid response. And then the response is more attacks. You know, it's many people who aren't Dr. Keither might be dissuaded from continuing to go forward under those circumstances. I think that was, one could fairly take away that that was the goal of those actions there, but that's where we're at. So, sorry for such a long preamble here, but let's get to the actual documents themselves. And I want to be clear that this document is going to be quite shocking. It's going to be an attack on me personally, but I think all that's resolved, and I'm quite comfortable and confident that these issues have been successfully reviewed, and it's clear what the actual law is. I think it was clear what the actual law is before she wrote that. I think it should have been clear to her what the law was, and I think, moreover, I told her very clearly what the law is before she wrote this. So even if in her 8 years experience as being an administrative law judge, she didn't understand this concept, we again told her and told her that we told her, but she still went forward. So let's get into it. All right. This is July 29th, 2022. Letter to Ben Hitchcock Cross regarding Jose Garcia Joven. And like I say, it might just say Garcia Joven, but it's pretty clear that this is also about Dr. Angela Ford, and it's also about Dr. Debbie Keither. So, dear Attorney Hitchcock Cross, following our pre-hearing conference on June 14th for this case, on Thursday, June 16th, I received an email from you regarding our discussion about the relevance of Dr. Holliday and post-complaint acts and general allegations of discrimination against the respondent. That means Milwaukee Public Schools. Okay? So let's just go look at that for a second because we've got it right here. There we go. All right, so this is my letter to Judge Brown regarding Dr. Holliday and relevance, okay? So at this point, Judge Brown said that nothing regarding Dr. Holliday was relevant to Dr. Garcia Joven's case, even though he's a supervisor and actively participating in the retaliation and so forth. And we're going to get into the reasons for that, but that I think is probably the first and still is the most troubling ruling that Stephanie Brown made. We've got, man, we're going to have a lot of information on that. But the concept here was really because Dr. Holliday was a bad actor in Dr. Keither's case, it wasn't, we were just using Dr. Garcia Joven's case for Dr. Keither's case, even though we could just go do it directly in Dr. Keither's case. So therefore, because Dr. Holliday is mentioned in Dr. Keither's case, he's not relevant to Dr. Garcia Joven's case. Okay, so that's, I mean, it's just preposterous. It doesn't make any sense, and we'll get into that, but that is essentially what we were getting into, or I would say facing. So, Judge Brown, in reviewing my notes from Tuesday's conference on Garcia Joven and other issues, I recall that we discussed the relevance of Dr. Holliday and post-complaint acts and allegations of discrimination against the respondent. So we're all clear that we're talking about the exact same letter, right? Okay. I noted there was some confusion about whether the respondent raised the defense of Dr. Holliday's and the subject of relevance generally. So I write to clear up those issues. Our brief specifically cites the fact of Dr. Keither's exposure to the media, of the fact that at Milwaukee Public Schools used her complaint against Dr. Holliday and then used Dr. Holliday against Dr. Garcia Joven within about a month, caused the Milwaukee Public Schools to terminate the services of the city attorney and hire Von Briesen, which was then used as a cynical reason to delay discovery. I also note that the department originally denied, this is when we say the department, we mean the Equal Rights Division and Matt White here, denied the existence of the Holliday complaint. Because it's true, that's what happened. I am attaching the complaint narrative of Angela Ford, whom I also represent, indicating that Dr. Holliday continues to use race when making employment decisions. Okay? And that's specifically that he told Dr. Ford, it pointed to his skin and said that she needs to take one for the team when they were discussing Dr. Garcia Hovan. Okay? There's a lot more to it, but that's the big headline there. So, hey, they're all connected. Dr. Holliday is all connected. We'll get into why they don't want to talk about Dr. Holliday, but that's a big problem. I know it's a big problem because the state of Wisconsin should not have secret rules about who and who you cannot bring up during an employment tribunal. Okay. I note that Angela Ford, being my client and also a witness, victim, and, unwilling perpetrator of MPS's racist management practices, Dr. Holliday brought her into his confidence because of Angela Ford's race. Does not prevent Dr. Garcia Hovan from asking questions about her, Dr. Keither, or other members of the curriculum department, and any other relevant information about the respondent's employees. My representation is not a test for relevancy. So that's going back to what I was saying before about how she's saying because Dr. Keither is asking about Dr. Holliday, therefore Dr. Garcia Hovan can't. Again, what law basis, I don't know, but we'll see. All right. Admissibility is also not a test. And let's just see, here's the law here. This is Wisconsin Statute 80401, sub 2, sub A, and is saying parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case. So what I'm saying there, considering the importance of the issues at stake at the action, the amount of controversy, the party's relevant access to the relevant information, the party's resources, the importance of discovery and resolving the issues, and whether the burden or expense of the proposed discovery outweighs its likely benefit. Okay, so I didn't hear anywhere in there whether a co-worker of yours is also alleging that this supervisor did something. Do you see that? Because I don't. So that's, again, that's our point. Judge, you can't just make up a law and say, oh, there's this secret rule that I know about. And she does ultimately, I think at the hearing, she says that common sense is the basis of her decision. So, not the law, not cases, but common sense. Okay? The problem is that you could go to common sense maybe if there wasn't a law. But the law is the first place you go to. So that doesn't seem to be the preference there. So let's keep going back and look at this letter here. All right. And making arguments, the argument that such information is relevant to the case, that's what we just read, and discovery should be allowed on those topics. And see, keep in mind, she doesn't respond to the arguments. That's, I think, moreover the key thing here, is she never responds to the fact that it's clear that she's wrong about whether or not that I represent two different workers, co-workers, means that one can't ask questions about their same supervisor. She doesn't address that. All right. In making the arguments, its relevance should be allowed on this topic, you provided portions of a discrimination complaint you filed with the Equal Rights Division on behalf of Angela Ford. I sure as heck did. An individual you disclosed you represent against Milwaukee Public Schools. I not only did disclose that, I filed a complaint with the Equal Rights Division, signing it myself. So, yeah, I represent her. Okay. Learning that you are representing Miss Ford, that's Dr. Ford, thank you very much, and her own discrimination complaint concerns you. Oh, let's find out why. It has raised questions about confidentiality. And again, passive voice alert. I guess I better get a button for that. It hasn't raised any issues. You, Stephanie Brown, are raising these issues. It didn't just blow in by the wind, let's be clear. I mean, maybe there's some other communications I don't know about, but otherwise, the source here is Stephanie Brown. All right. It concerns me, right? All right. As Miss Ford is a key witness in Dr. Garcia-Hoven's case. Totally agree. Dr. Ford is a key witness in Dr. Garcia-Hoven's case. No question about it. Because Milwaukee Public Schools pitted the two of them against each other. No question about it. All right. In fact, Dr. Garcia-Hoven alleges that Miss Ford discriminated against him and harassed him. So I would say bullied, but yeah, he did. No question about it. It would seem that they could be directly averse to one another in this case, and your representation of both of them could be problematic. Okay. And this is ultimately, I think, where the rubber hits the road here, and why we're doing this video that's so long. Thank you, everybody, for sticking with me here. So, Wisconsin, under the Wisconsin Fair Employment Act, an employee cannot be liable. Only an employer. Okay? So that means that if, let's just say, that Angela Ford is the worst discriminator in the whole world, and she personally discriminated against Dr. Holland. Okay? She couldn't be liable for it. MPS could be liable in theory if that were the case. In theory, there would have to be some other events that would have to take place. But MPS would only be liable because it would have failed to act to stop Angela Ford from discriminating against Dr. Garcia-Hoven. So that doesn't have to be the case, of course, what happened at all. And we'll, I'm sure, get into that. We've got all that there. But the problem here is why Judge Brown should know that fact. Judge Brown, if you go into the Equal Rights Digest here, and we can do that, it will say, let's just pause. All right. Always go right to the source, right? All right. Wisconsin Fair Employment Act. Who may file a complaint? Against who a complaint may be filed. All right, let's look at this. So this is right at the beginning. Okay? Let's look at this one here. Hoey versus County of Fond du Lac. Where an individual person has acted under color of his or her authority as an agent of the employee, the employer, rather than the individual person, is properly held liable as the respondent. Okay? So we can go back to that there, but she knows that. And if she doesn't, that's a bigger problem. But she knows that. And she knows that because even if she wasn't an ALJ with 8 years experience, we told her that in previous briefings, as I mentioned before. So that I think is the biggest problem with that. She knows they're not, and directly adverse here, just so we're clear, means that they're on other sides of the case. So Milwaukee Public Schools is directly adverse to Dr. Garcia-Hoven. Milwaukee Public Schools is directly adverse to Dr. Ford. Milwaukee Public Schools is directly adverse to Dr. Keither. Dr. Keither is not directly adverse to Dr. Ford. Dr. Ford is not directly adverse to Dr. Jose Garcia-Hoven. Okay, that's just the law. So that's really the only way to look at that. I mean, it's just the law. She cannot be held liable, therefore they're not directly adverse. Okay? It might be problematic, there's other issues, fine. But they're not directly adverse. It may be, let's say, something that the department doesn't want to deal with, but that's not the same as saying that it's unethical. And that's what she's going to accuse me of going forward here. So, because of my concerns, I reviewed the Supreme Court rules relating to professional conduct. Attorneys as it relates to confidentiality and conflicts of current clients. So, Supreme Court Rules 21(6)(a) provides that a lawyer shall not reveal information relating to a representation of a client unless the client gives informed consent, except for disclosures that are impliedly authorized in order to carry out the representation. Okay, so it clearly says that, and this is why I can talk to all of you about it, is because I have been authorized by my client to disclose the fact that and information relating to representation. But the key word says reveal. So I can tell you both that I represent them and information regarding the case, which I would ordinarily be forbidden from doing without their express permission, which she has no idea of knowing whether I have their express permission or not, but it is going to be clear what her problem is with that as we go down. Okay? Now, here's this other one, this conflict of interest. 21(7) provides that, except as provided in paragraph B, a lawyer shall not represent a client if the representation involves a concurrent conflict of interest. A concurrent conflict of interest exists if, 1, the representation of one client will be directly adverse to another client. So we've gone over that. There is a significant risk that the representation of one or more clients will be material limited by the lawyer's responsibilities to another client, a former client, or a third person by a personal interest of the lawyer. Okay, so that's not going to apply here because I don't have any financial interest involving MPS or any of the business interests, etc. So that's what that's looking for, is a financial interest between attorneys. Don't have it. So, notwithstanding the existence of a concurrent conflict of interest under paragraph A, a lawyer may represent a client if the lawyer reasonably believes that the lawyer will be able to provide competent, diligent representation to each affected client. So that means that I have to go and check out whether or not I think that I can continue to represent them fairly and honestly. Okay? The representation is not prohibited by law. The representation does not involve an assertion or a claim by one client against another client represented by the lawyer in the same litigation or other proceedings before a tribunal. Okay? So that's the key thing there, that they're directly adverse. Or each affected client gives informed consent confirmed in writing signed by the client. Okay? Those are the steps that have to be taken in order for me to represent somebody who's got a concurrent conflict of interest. And that's probably going to happen anytime that we have coworkers working for the same employer where there's the same supervisor. It's very likely that there's going to be enough of an overlap there that I'm going to be concerned about whether or not I can diligently represent them to the extent that I have to go through this entire process with everybody that's involved. Okay? So, the judge has no concept of whether or not this has happened, but yet she's putting this in writing. I wonder what the purpose of that is. Let's see what she says. We'll see if we think that's credible or not. I want to be transparent with you and disclose my concerns. I am not asking you to disclose your communications with Dr. Garcia-Hoven and Ms. Ford about a potential conflict of interest. That's, let's say that there is a maxim out there that I think is, in my experience, is universal, and it says, never believe anything until you hear it officially denied. I am not asking you to confirm that you have obtained informed consent in writing from Dr. Garcia-Hoven and Dr. Ford regarding your representations of them both. I trust you have communicated to Dr. Garcia-Hoven and Ms. Ford that you represent both of them and potential issues that could arise given your concurrent representation. I assume you have considered potential issues and determined that you are able to provide competent and diligent representation to Dr. Garcia-Hoven and Ms. Ford in their respective discrimination complaints. Oh, well then why put this in writing here? I wonder. Okay. It is not the Equal Rights Division's role to ensure attorneys are following their professional rules of conduct. Okay. We expect the attorney. So that's not actually accurate. To be clear, all attorneys have the responsibility to make sure that all other attorneys are being ethical. So she can't claim that there's some policy there that allows her to hide behind that she's exempt from the requirements of the Supreme Court. So we expect attorneys that appear before us to follow those rules. However, I decided to share my concerns with you now, and of course the world, as I am concerned that if you determine at some point that there is a conflict of interest, and I'm going to tell Milwaukee Public Schools all about it, that requires substitution of counsel, the proceedings in Dr. Garcia-Hoven's case, as well as Dr. Ford's case, could be delayed as they seek alternative counsel. That's something I think no one wants, or it's unlikely to become an issue, hasn't become an issue, and, I guess that's, let's put it like this. I'm skeptical of that being her reason for writing this letter. Finally, I want to address my concerns about confidentiality, and here it comes, as it relates to the two cases I have involving your clients and Milwaukee Public Schools. I have noticed that at times you copy Deborah Keither, that's Dr. Keither to you, another one of your clients when communicating with me by email about Dr. Garcia-Hoven's case. And sometimes you don't copy Dr. Garcia-Hoven on those emails. You should have noticed that I removed Dr. Keither's email addresses when responding to emails in which you have copied her. So I just want to be clear on this. I think the practice there was when everyone thought that let's say Stephanie Brown, ALJ Brown, needed more, the concept of more oversight, that Dr. Keither was more than happy to participate, to, let's say, view, to, and I guess by participate I mean go into hearings, and to be copied on letters to Judge Brown. I've also copied people from my law firm. I've copied reporters on letters to Judge Brown. I've copied the secretary of her department. Let's say Dr. Keither is not unique in that circumstance there. But what does make her unique, again, is that she has a case about against MPS in front of Judge Brown. And let's just say, for example, that I wanted to copy Dr. Keither on everything from Judge Brown because Dr. Keither wanted to learn about that. These are public records. And let's say you wanted to get a copy of this record, you could just go ask them for it and they would have to give it to you by law. So what harm there could possibly be in copying somebody on a public record, I'd like to know, but maybe she'll tell us. All right, I ask that you stop copying Dr. Keither on your communications to the Equal Rights Division that do not specifically involve her discrimination complaint. I will continue to remove her email address from any emails to which I reply to that do not pertain to her discrimination complaint. See, now that's a positive action that she does have. I mean, it takes work to do that. So if that's something that she wants to spend the state's time doing, I mean, I obviously can't stop her there. But again, that's why we say that she's taking steps. I mean, it's one of the reasons that we say that she's taking steps to prevent Wisconsin workers from coming together. All right. Now, this, I think, is another kicker here. The Equal Rights Division has not consolidated these cases for hearing. Further, I will not consolidate Dr. Keither and Dr. Garcia-Hoven's cases for hearing. Why not? I mean, nobody asked you to, but I don't know why not. She doesn't give a reason. She just says she won't do it. So, when a judge says they're not going to do something, they should pretty much give a reason for it. They got to have a rational basis here. I don't get it. I've also noticed that at times there is discussion of both cases in the same communication. Now, that's fair enough. When you mentioned Dr. Keither had an email relating to Dr. Garcia-Hoven's case, I am required to attach that email communication to Dr. Garcia-Hoven's file. I mean, I guess that's work, but not certainly any more work than removing Dr. Keither's email. I have tried to limit my communications with you and opposing counsel to discussing only one case in the communication. I guess that's fair, but, I get it. But the point is that, for example, they have the same supervisor. They're peers. They work in the same environment. The fact that MPS is been caught making false statements and delaying discovery and other making false representations, other things like that, in one case is also related to the other case. So when you put up an artificial wall there, that's only helping Milwaukee Public Schools. All right, to maintain accurate records for both cases, we need to keep documents and communication for these cases separate from one another. Okay, now, here's the kicker. I will include a copy of this letter in the Equal Rights Division's electronic file for Dr. Garcia-Hoven's discrimination complaint. I am also including a copy of this letter in the Equal Rights Discrimination electronic files for Angela Ford's case and Dr. Keither's case. So I guess you could do it on Dr. Keither's case. But see, now that's her mentioning Dr. Keither and her causing that problem. It's Dr. Ford's case that's not been sent to hearing that's going to cause the problem there. And it is extremely prejudicial, and we'll get into that because we responded on that issue. I'm also including a copy of this letter in the Equal Rights electronic file for it's the naughty list. This is really taken by me as a threat. But it's a threat in such a way that it's designed to harm my client's interests collectively. I appreciate your anticipated cooperation moving forward, and then, of course, she also sends it to MPS. Chris Reardon, respondent's attorney. Okay, that's what she did. We have a response, of course. We'll get there. But so we asked Judge Brown, like I said, to remove herself from the case. She refused to do that. And it's extremely problematic here. But one of the reasons that we put forth, and I think we'll get into this, it's going to have to be another video, it's quite long here, there's a lot of grounds. Dr. Keither and other parties before the Equal Rights Division have a right to organize. So one of the bases that we feel that Stephanie Brown should have removed herself from both Garcia-Hoven and Keither's case is because she took active steps to try to keep them apart. So, on July 29th, you wrote a letter directed at Ben Hitchcock Cross, yours truly, regarding the Garcia-Hoven case and your thoughts on Garcia-Hoven and Ford retaining Ben Hitchcock Cross as their attorney. Although you discussed Dr. Keither, whose case you have, and Dr. Ford, whose ERD complaint you do not have, you also placed a copy of the letter in the case files of Dr. Keither and Dr. Ford. The letter is highly prejudicial, especially to Dr. Ford, and is clearly an attack on employee organization. Dr. Keither briefed the tribunal extensively on third-party witnesses and liability of employees under WIFA. Okay? So she knows here, and we're calling her out on the fact that she knows that Dr. Ford cannot be liable to Dr. Garcia-Hoven and that they're not adverse. She knows that. Yet, she's continuing to put that in there. The title of the investigator, let's say, gave to this letter is incredibly prejudicial to Dr. Ford, as it makes it clear that the letter had an effect and will serve to bias Dr. Ford. So the investigator has to make a log, and in that log it says letter on concern of ethics about me in the case file there. So of course that's the title that the investigator gave. Who wouldn't expect that she would have a prejudicial basis response to that, okay? And this is the kicker here, and I want to be really clear on this. This is the heart of the matter. And I couldn't have said it better than what I apparently had said at that time. So to put it frankly, Wisconsin workers have the right to freedom of speech, organize, assemble, assist, challenge, serve documents, oppose, appear in the media, make public records requests, finance, fundraise, and otherwise participate in holding the ERD democratically accountable without fear that such constitutionally protected efforts will result in prejudice. The ERD is open to all. So just, she responded with about a sentence and saying it was not obvious to her what the problem was, and that the letter should stay. She didn't understand how it was prejudicial. So again, that is when you come down to the rubber hits the road of at what point can you say, how does she not know that Dr. Ford cannot be liable to Dr. Garcia-Hoven and therefore is not an adverse witness? At what point does she need to retract the statements that she made that are incorrect? On what point do you say when you refuse to do that on at least 2 separate occasions, at what point do you say, what is the purpose behind doing this? What is the purpose behind putting it in the public record and giving this to MPS? It certainly generated a lot of motions from MPS. It certainly generated a lot of cost, fees, and other burdens on my clients, no question about that, so that we know the effect. So those are all the reasons here that we say that Stephanie Brown is attacking Wisconsin workers' right to organize here. So I appreciate you making it to the end. Thanks for sticking with us. We will keep you informed.